Namaste everyone. Let us see the next question in the PYQ series. Uh, the question is examine the limitations. Examine the limitations in amending any part of the constitution. So we know constitutions can be amended through various mechanisms, and then we have to examine what are the limitations that are there for the constitution. So before addressing this question, I want to clarify the difference between limitation and challenges. The same question could have been asked with the challenges, right? Limitations, they set a bar, okay? The challenges are something you can overcome. For example, if someone's height for an examination for the recruitment of police, say they have set a minimum criteria as say 170 centimeter, right? So if someone is below that is his limitation. If someone is 165 centimeter, and then that's his limitation, like he cannot become 170 centimeter, right? That's his limitation. But if it's a challenge, suppose if the same examination, if it has asked to cover say 1 kilometer, right, in say 10 minutes or so, if someone is unable to reach this, and then he can work on, he can improve, so that's a challenge for him. So in this context, what we are looking at is that, so what are the limitations that are set, on the on amending the constitution, okay? For example, if you have read the basic structure of the constitution, so one of the limitation is that basic structure. So basic structure is the limitation because it clearly says that some of the core values can't be destroyed, or can't be neglected, or can't be violated during the amendment procedure. So these are the core values, and these are the essential values, are the foundation values for the constitution. For example, so the values that are present in the preamble, right? You have sovereignty, democratic, republic, secular. So all these are the very fundamental for the existence of the constitution. So these are the core principles without which the constitution loses its meaning. So that's why, so whatever that is delivered under the Keshavananda Bharati case, so and plus over the time, so many other values have got added. For example, so judicial review, okay? Judicial review is as another principle. So these are the core values. So these core values, they set a limitation. These core values set a limitation because you cannot violate them. So can't violate these things. So this is one limitation for the amendment procedure. What is the second limitation? For example, you have Article 13. What Article 13 says? So any law or rule, so that is part of the amendment, or the any new laws that are made, they should not contradict fundamental rights. If the parliament is coming up with any law, if they are in violation of fundamental rights, so they stands to be void. So and hence Article 13 sets a limitation. So this is another limitation on constitution. That means that if some law is trying to violate the fundamental rights, they cannot be made under Indian constitution. So going further, what is the third limitation that is set? One we saw basic structure, the second one is we saw Article 13. The third limitation is judicial review itself. The third limitation is judicial review. So suppose judicial review is also part of basic structure, but either it could be legislature or it could be executive action. If they are beyond a reasonable, if they are seeming to violate either basic structure or fundamental rights, or if they seem to be violating the procedures established by law, or it could be executive overreach, right? Or it could be wrong implementation of the law. If such things are observed, so judicial review can always put a limitation. So the laws made by the parliament or the state legislature, they can't escape judicial review, right? So this is another limitation set by the constitution itself. Going further, if we look at the procedures done in amendment, for example, if the rules that are of the concern to the states, so they have to get the permission from the state, in the sense that 2/3 of the state should assent to the bill. So this is a kind of both limitation and a challenge. We cannot say it's a completely a limitation, because if the center can get the consent of the states involved, it can go ahead and pass the bill. But the point is that the states can actually set a limitation. So when the subjects the center is amending touches the federal aspects. Okay. Then the fifth limitation that is set. So the list under 7th schedule. So we have 3 lists: centers list, state, and concurrent. So this is also partly a challenge. Suppose if the things that are being amended, it could be of the state, or if it is touching the parts of the concurrent, it has to get the permission of the state. For example, it could be some international conventions. So there is a so we cannot clearly say that the center has to get the permission of the state always, because India being a sovereign, it depends on the center at that time, like how it is going to handle the situation. Suppose if it is necessary to get the permission from the states, it can get the permission from the states. But many international conventions, generally they do not require the consent from the state. So that's also one criticism when we deal with the federation or the issues of the federation, right? The states constantly say that our interests are being ignored, or whenever it comes to like giving the assent to any international convention, say Paris Climate Agreement, etc., right? The concerns of the states are ignored, and then these issues are handled by center single-handedly. So that's another issue. These are the major issues or major limitations when it comes to amending the constitution. But you can also say a few challenges in this question, like if you want to really add some of the minor points. For example, you can always say like preamble. So preamble itself is a limitation, in the sense that we cannot ignore the like ethics behind the preamble, right? Or we call it as constitutional morality. Right? So those who are amending cannot go beyond this. So then there are certain challenges. For example, so I can say popular support, but this is a challenge. Like the government which is trying to amend the constitution should have a popular support. If it is not a popular support, so then it leads to legitimacy issues, right? But this is exactly not a limitations on the amending part, but this is actual challenge. If the state is not having a proper popular support in the sense that it should have a consent, or it means that acceptance by the people, in simple words. For example, the center has amended Article 370 but the question is that, was it popular support? Was it based on the popular support? Did it really enjoy the consent of the majority? So that's debatable, right? We cannot say whether it's right or wrong. Like, so those state has done it. So there were criticisms and debate in the way that is done. The intentions could be right, but the procedural aspects were questioned. Aspects in under the Supreme Court. So in that context, we can also say that we can also discuss few challenges also, not exactly the limitations, but the core answers, the core points of the answer deals with the first one is basic structure, the second is Article 13, the third is judicial review, then the fourth one is about the states and especially things under 7th schedule. So these are the core aspects of the answer. So if you are covering 5-6 points and then with brief explanation, this is a good for 150 words, 10 marks question, right? You can also add some of the examples, say examples in the sense that like how center faced issues in amending, say, farm laws. You can say farm bill when it was trying to amend in 2020, right? So these are some of the limitations that are part of the answer for this question. Thank you very much.